In 1978, a baby girl was born in England. Her name was Louise Brown. She was then known as the test tube baby. She was created in a petri dish outside of her mother's womb. Fast forward 40 years in the area of assisted reproductive technology, you now have couples, and in some instances individuals, who combine gametes, which are female eggs and male sperm, to create embryos. And these embryos are then often stored. Some are used right away and others are stored in order to have children at some future date, in some instances immediately. Those gametes can either be created by the couple themselves or in some instances with a third-party donor. Historically, those donors were unknown and would have no rights if children were born as a result of them. More recently, what we see is family members or friends serving as the donor, which can complicate both the control of the embryo and the resulting parental rights once the child is born. I'm involved in several cases where couples have created embryos, have stored embryos, and not yet used them. During the course of creating those embryos, they found that they couldn't stay together as a couple and have either divorced or broken up. The issue that arises at that point is who keeps the embryos? In New York, it's very difficult to enter into an agreement regarding an unborn child, and for these purposes an embryo would constitute an unborn child. So you cannot, by agreement, determine custody or support obligations for that unborn child. That being said, parties, before they're having a child, try to discuss what happens in the event they break up. So the current law in New York is that we treat embryos more like personal property than as a living thing. That's different than it is in Louisiana. It's different also than it is in California, where they're trying to create a best interest test. Here we look at it more as personal property and what the parties contract to. In New York, the law is you cannot contract regarding custody or support of an unborn child and hope that that contract would be enforceable. However, as recently as a few weeks ago, the New York Court of Appeals upheld a decision which said that a commercial contract entered into between the parties and a IVF clinic is, however, binding as to the disposition of embryos. And in that instance, if there isn't an agreement between the parties, then the embryos are either returned to further research or destroyed. Well, there are two aspects to an AR agreement. The first aspect is the clinic contract itself, which is generally a boilerplate commercial contract, which the New York courts seem to be enforcing to the exception of other contracts at this point. And those contracts provide for the disposition of embryos, either dedication to further research or destruction in the event the parties cannot agree on what to do with the embryos. I strongly counsel clients who are entering into these kinds of agreements to make sure they understand the disposition clauses for their embryos and make sure they're consistent with their wishes. You can also enter into a separate agreement with your spouse or your partner as to the disposition, but I also counsel clients that those are not strictly enforced in New York because they deal with the issue of an unborn child. The law in this area is evolving around the country. New York seems to be a little bit more slow than other jurisdictions, but I think that they're sooner or later going to have to face the fact that an embryo is not just personal property that can be distributed pursuant to a form contract that you sign with a clinic, that it's going to require additional considerations by a court to determine best interests of each party, best interests of the child. These standards are already being applied in other jurisdictions, and I expect they'll equally be applied here in New York in the future.